I've been a law professor since the early 1980s, and I have been interested in debt collection, the case where a debtor just refuses to pay, and what can the courts do about that? And a couple of principles that are sort of hornbook law is if the debtor owes the creditor a sum of money, the creditor has no property interest in the debtor's stuff. My article, I refer to a gold brick, so I'm going to talk about the debtor owes a gold brick. The creditor has a claim against the debtor. The creditor has zero interest in the gold brick. So the debtor won't pay. How does the creditor get anything? And the answer is the creditor gets a money judgment, serves a writ of execution on the sheriff, and the sheriff takes the gold brick, sells it, gives the money to the creditor. So that's the basic debtor-creditor model. And in this model, the creditor owns nothing until the lien occurs, and then the creditor has the right to sell the lien once the writ of execution is delivered to the sheriff. Now, what happens if the debtor gives away the brick so that the creditor can't get it? One of the odd things about fraudulent transfer law is that the minute the debtor with the gold brick, which the creditor doesn't own, the minute the debtor gives that to a third party, who I will call X, the minute the debtor gives the gold brick to X, the creditor has a property interest in X's brick. And the debtor has alienated the brick. The debtor has zero to do with the brick. The brick is held by X for the benefit of the creditors. And in state law, the first creditor to bring an action to avoid the conveyance gets an equitable lien on the brick. And so now the creditor is a secured creditor with the brick. All right, now, what happens if X, holding the brick for the creditor, gives it back to the debtor? Well, the creditor has a lien on the brick, so X can only take the brick minus the creditor's lien. And so it's impossible for X to give back the fraudulent transfer on that property model.
Let's say a creditor has an unsecured claim against a debtor. The creditor does not have property rights in the debtor's property, correct?
That's right.
Okay.
He's called a general creditor as opposed to a specific creditor. I'm using 19th century language. The creditor with a lien would be a specific creditor with something, but the general creditor has nothing. Where X has the brick and refuses to give it back to the debtor.
Correct.
Well, there's the brick. Bring the action, the avoidance action. The commencement of avoidance action in many states, though not New York, but in many states, the commencement of an avoidance action brings the brick in custodia legis. The court now has the brick, and the creditor has established a priority right to the brick. No other creditor can do better than our creditor having commenced the action. So then the court decides if the predicates of the fraudulent transfer have occurred. Did the debtor intend to hinder, delay, or defraud creditors? Or was the debtor insolvent when the debtor made a gift of the brick to X? The court decides the predicates are there, and there will now be a judicial sale of the brick. And a receiver or a sheriff will sell the brick, give the proceeds to the creditor, and if there's a surplus, we'll give it back to X, not to D, because D has given up the brick. D has no claim to the surplus anymore. X has the surplus. Okay, well, let's take a slightly dramatic version of that creditor. The debtor takes the brick and disappears to Switzerland and is never seen again. X gave it back, but the brick is just not available. Okay, well, X received a fraudulent transfer, and that meant that that X held the brick in trust for the first creditor to come along. Now, X's duty here as trustee of the brick is to hand the brick over to a sheriff or receiver when that occasion arises. But X didn't do that. X gave it to the debtor and the debtor absconded. And so X is still liable. Giving it back is no defense. I make a comparison in the article to a bad faith purchase for value, or what used to be called a bulk sale. This is where the debtor has inventory or something. The debtor wants cash to get out of town, so the debtor sells the cash, the inventory to X, and says to X, "I'm getting out of town the minute you give me cash." X says, "Well, I don't care. I just want the inventory. Here's the cash." Debtor leaves town without the cash. That was a classic bulk sale, bad faith purchase for value. That was an intentional fraud on creditors. Well, X gave money to the debtor and has no defense, and the debtor has taken the money to Switzerland. So no defense for X there. But now we change the facts, and there's a gift to X, and debtor says to X, "Give back the gold brick." X gives back the gold brick and goes to Switzerland. Well, we didn't give a defense to X in the bad faith purchase for value. Why should we give it in the give back situation? Yes, and one of the things I do in my article is to revive a 19th century doctrine, very well understood in the 19th century, but forgotten today. This is the bona fide donee defense. And it's based on the idea that an innocent transferee like X, who doesn't know that there's a fraudulent transfer, does not hold the thing in trust at all for the creditors. So X could, as I say in my article, X could take the gold brick to a casino and gamble it, or X could give the brick back to the debtor. Either way, the brick was never held in trust for the creditors because the debtor was an innocent donee. So the trust kicked in only when the donee knew or learned later that it was a fraudulent transfer. Then X holds the thing in trust for the creditors. And the only way to execute the trust is to give the gold brick to the creditor's sheriff or receiver. So that is a kind of bona fide defense. It's not a bona fide purchaser for value defense. It's less than that. All that X has to do is to show that X is a good faith donee who never knew there was a trust. And we're not going to hold X responsible as a trustee when X didn't even know he was a trustee. That was the 19th century instinct. Now, there's nothing in the Uniform Fraudulent Transfer Act to counteract that. In the Uniform Fraudulent Transfer Act 8C, it is said that judgments against X for money are subject to the equities. Well, this was a 19th century equity. And so I read the Uniform Fraudulent Transfer Act as admitting the bona fide donee defense. Well, it was solid 19th century law, and my article sets forth the many citations to the 19th century situation. Along comes the Uniform Fraudulent Conveyance Act in 1918 and doesn't even speak to this. But you could find cases that say, well, the Uniform Fraudulent Conveyance Act is incomplete legislation, and unless it explicitly overrules equity jurisprudence still breathes and reigns. And the UFTA is the same way. 8C says the equities still govern. So this is a solid 19th century equity. Now, admittedly, I don't think I was not able to find modern instances of this, but there's no statutory reason why we shouldn't go back to the 19th century and protect the innocent donee who never knew he was a trustee. But notice this is not a give back defense. It's just the idea that the donee is not a trustee for the creditors. If the donee gambles the gold brick away, or the donee gives the brick back to the debtor, same thing. X did not know he was a trustee, and we're not going to hold X responsible for breach of fiduciary duty. Well, I think the problem is that for the last 100 years, no one has really concentrated on what a fraudulent transfer is. So when the debtor alienates 100% of the gold brick, says goodbye to it and has no legal interest in it whatsoever, and this is done to hinder, delay, or defraud the creditors, that's a fraudulent transfer. But if the debtor retains an interest, let's take two examples here. One, the car in the garage. With a bailee, the legal and equitable interest is in the debtor, and the garage holds the car at the behest of the debtor. The debtor can cancel the bailment at any time. Debtor goes bankrupt. The legal and equitable interest in the car go into the bankruptcy estate. The power to end the bailment goes into the bankruptcy estate. The trustee can exercise that power and say, give me back the car. If the garage says no, the trustee can bring a turnover action because this is property of the estate in which the trustee has both legal and equitable title. On the other hand, if we have a fraudulent transfer, there's got to be an adversary proceeding, because avoidance is something different from collecting on a bailment. Well, people have forgotten what a fraudulent transfer is. They see something the creditors don't like and they say, oh, it's a fraudulent transfer. Let me give you a big example of that. The Ponzi scheme, not a fraudulent transfer. In a Ponzi scheme, a fraudster bilks a victim out of his money. The fraudster takes the money in trust for the victim. Now, the fraudster goes into bankruptcy. The trustee does not inherit the victim's equitable interest. The victim has the equitable interest, the trustee does not. So if the trustee sues the Ponzi artist in bankruptcy, properly speaking, that's not an action the trustee can bring. The asterisk has to do with the Securities Investment Protection Act, or SIPA, in which a stockbroker goes bankrupt. Well, that was Bernie Madoff. Now, in SIPA, there is a provision which says if the broker bilks customers out of investment funds, the trustee has standing to get those funds as if it was property of the estate. So SIPA makes the Ponzi scheme into a fraudulent transfer. So properly speaking, Mr. Picard, who is suing everyone in the world for fraudulent transfer, he's quite correct. Under SIPA, that is a fraudulent transfer. But if we don't have a stockbroker and we have, like the classic Ponzi in the 1920s, he was bilking victims out of their money, and he was holding their money in trust for those victims. When Ponzi went bankrupt, the victims give up nothing to the trustee. The victims continue to have the right to sue Ponzi, and the trustee for Ponzi doesn't have that right. Right. And that's because the trustee does not step into the shoes of the equitable rights of victims. And there's case law to that effect. Now, this is all just forgotten, just completely forgotten in most Ponzi scheme cases because courts don't focus on what a fraudulent transfer really is. They can't distinguish between a constructive trust and a fraudulent transfer. Now, in our context, courts cannot distinguish between a resulting trust and a fraudulent transfer. They're two different things entirely, and this has a big impact for givebacks. If we have a resulting trust, the holder of the gold brick owes no duty to the creditors. The holder of the gold brick owes a duty to the debtor and only to the debtor. If the holder of the brick gives the brick back to the debtor, that's executing the trust. This is a noble exercise of a fiduciary duty to give back the brick, and the creditors can't complain. On the other hand, if it's a fraudulent transfer, X has the brick in trust for the creditors, and giving the brick back to the debtor is not executing that trust, and the give back is not a defense. A debtor makes a fraudulent transfer to his sister-in-law X, and just before bankruptcy, the debtor says, give the money to my wife, or give some of the money to my wife and give some of the money to my LLC. So X, the sister-in-law, says, okay, you're the boss, and gives the money to the wife and to the LLC. None of this money is ever seen again. The debtor goes bankrupt. And the Fifth Circuit says, well, this is obviously a give back, and it's defended. Well, the wife and the LLC are off in Switzerland enjoying the proceeds. How did the creditors, benefit from this? So it strikes me that the Fifth Circuit was dead wrong. Now, if you read that Fifth Circuit case, it's a very arrogant opinion. It's saying not only is a give back obviously a defense, but the lower courts are guilty of judicial malpractice in saying otherwise. Well, no, givebacks are not necessarily a defense, and there are two other circuits holding that givebacks are not defenses, and these are not properly acknowledged by the Fifth Circuit. So it was that case that spurred me to write the article. Well, exactly so. Soon after my article, a bank called me up and it had been involved in a check kiting scheme as a bank. There was a check kiting going on, and they were being sued as a fraudulent. They were being sued because this was allegedly a fraudulent transfer. Well, it isn't. It's a constructive trust situation, not a fraudulent. Being sued for fraudulent transfer in the Fifth Circuit. So I said, well, I just came out with this article. It was a week old, so I emailed them the article, and they were unaware that a give back was a defense. Now, in a check kiting scheme, they give back. A bank will give back the value received a lot, and so that was a defense they could use in the Fifth Circuit. Well, I think it's settled in the Seventh and Sixth Circuit going the opposite way. So it's time for the Supreme Court to take cert and tell us what the story is.